Assalamualaikum. My name is Mikael Muiz. Today, my friend and I will be presenting about Access to Medical Report Act 1988. So, as a general rule, medical report is confidential. It can only be accessed by the patient and his medical practitioner. So, the amendment of this act is basically to establish a right of access by individuals to reports relating themselves as provided by medical practitioners for employment or insurance purposes and to make provision for related matters. So, the insurance purposes in this act can be defined as in the case of any individual as meaning the purpose in relation to the individual of any person carrying on an insurance business with whom the individual has entered into or is seeking to enter into a contract of insurance. So, I'll give Muhammad Nur Ramdan to present the next slide.
Okay, in section 3, a person should not apply to a medical practitioner for a medical report relating to any individual to be supplied to them for employment or insurance purpose, unless the applicant has notified individual that they propose to make the application, which means the applicant need to tell the person that they want to take the medical report. And B is the individual has notified the applicant that they consent to the making of the application, which means the individual agreed to give the medical report to the applicant. So next, I'll give to Muhammad Ridwan to continue the presentation. Thank you.
My name was Ridwan. I will explain about section 5. So in section 5, we have two subsections, which is 1 and 2. For section 5, section 1, where an individual has been given access to a report, the report should not be supplied in response to the application in question unless the individual has notified the medical practitioner that they consent to it be supplied. For section 5, subsection 2, the individual should be entitled, before giving their consent under subsection 1 above, to request the medical practitioner to amend any part of the report which the individual consider to be incorrect or misleading, and if the individual does so, the practitioner. So, in the subsection 2, section 5, we have divided into two, which is A and B. In subsection 2, section 5A, should amend the part accordingly if they are to any extent prepared to accede to the individual request. For subsection 2B, should attach a statement report if they are any to extent not prepared to accede to it, but the individual requests them to attach a statement of their view in respect of any part of the report which the medical practitioner is declining to amend. So that's it for section 5. So the next slide I give it to Adiman to explain about it.
Okay, for section 6 under this act, for subsection number 1 is a copy of any medical report which a medical practitioner has applied for employment or insurance purpose should be retained by him for at least 6 months from the date on which it was supplied. For number 2, subsection 2 is a medical practitioner should, if so, request by an individual, give the individual access to any medical report relating to him which the practitioner has applied for employment or insurance purposes in the previous 6 months. Subsection 3, the reference in subsection 2 above to giving an individual access to a medical report is a reference to making a copy of the report available for his inspection only, and B, supplying him with a copy of it. And under section 3, section 6, subsection 3, where a copy of the report is supplied at the request or otherwise with the consent of the individual, the practitioner may charge a reasonable fee to cover the cost of supplying it. So that's all for us today. For our group under this Medical Act 1988. So thank you.